Welcome back to Legalese 123, where we are covering cases across America. Hello, and welcome to Legalese 123. I'm your host, Missy K. It is the 29th of June. Can you believe it? June is almost already gone. Wow. All right, law lovies, it is a new situation. We have the Alec Murdaugh trial going on. That's right. Why? Why, Missy? Why? Well, let's go ahead and post that I am the live. See if we can get anybody to join us. All right. Just post. Why does it say tomorrow? Today is the 29th. Oh, technology. All right. So Alec Murdaugh is wanting to get back into it. Well, as you remember, Alec Murdaugh was a prominent attorney in the Low Country in South Carolina. He has a lineage of people who go to law school, judges and other lawyers in his family. He was married to Margaret or Maggie. He had two sons, Buster and Paul. Back in okay, when did all right. So his younger son, Paul, had a fatal boat accident on February 24th, 2019, and 19-year-old Mallory Beach was killed. Some of the other victims were injured as well. Paul was called grossly intoxicated operating the boat. Paul was subsequently indicted on 3 felony counts of boating under the influence and causing the death or great bodily harm, and he pled not guilty. So what happened thereafter was Maggie and Paul were killed, right? And subsequently, Alec Murdaugh was charged. Well, after that boating accident, what sort of like made the steps to go to where they were was that Alec Murdaugh was skimming money off of his trials, right? So he was a civil attorney who was doing injured cases, etc., and he would make a fair, decent amount of money, but he was taking the money from his clients and he wasn't giving it to them, instead spending it on himself. He also stated that he was using the money for opioids and what have you. Is that a motivating factor in the deaths of Maggie and Paul? The answer is yes. So if you're just joining me, we are going to be going over a hearing that is happening for Alec Murdaugh. As you know, Alec Murdaugh was convicted of killing his wife Maggie and his son Paul. That happened in well, I don't know. Okay, Alex Murdaugh was once a prominent, wealthy personal injury attorney from a powerful, multi-generational legal dynasty in South Carolina's Low Country. His life unraveled after his family became embroiled in the fatal boat crash in 2019 involving Paul. And on June 7th, 2021, Maggie and Paul were found shot dead near the dog kennels of their house called Moselle. Many of you have seen the Hulu series that came out. There have been other many talks and stuff like that that came out. And as you know, Alec Murdaugh went on trial and he was convicted, right? He was convicted of killing Maggie and Paul. Well, then, as you might know, there was this person. Her name was Becky Hill. She was the clerk of court in South Carolina. And she was writing this book and she wanted to be famous. And she basically inserted herself and talked to the jury when she wasn't supposed to talk to the jury. So, as you know, Alec Murdaugh was convicted. He went up on appeal and he got his appeal. So, Alec Murdaugh is going for a hearing today for his new trial. And if you have heard that the prosecutor in this case, Mr. Creighton Waters, he wants this case to move forward and get this done by this year. Will it happen? I don't think so. Okay. So there were some motions that were filed last week, so we're going to kind of catch up on that, and then we're going to get to the hearing today. Another motion filed Wednesday by the defense asks the court to order prosecutors to make available DNA evidence from Maggie Murdaugh. Apparently, there was DNA that was found underneath her fingernails following her murder for independent analysis by an outside laboratory. Ortham Labs. Have you heard of Ortham Labs? If you haven't, guess what? Ortham Labs was used in the Kohberger case. The defense contends that the filing that the DNA was not analyzed further after it was determined to belong to an unknown and unrelated male. Forensic genealogy company Ortham reportedly believes it can conduct a more thorough analysis of the evidence according to the motion. Any expenses incurred from Ortham for the future analysis would be paid at Murdaugh's expense. The final motion contains a request for Murdaugh to be provided with a laptop for the use of his during presentation for the trial due to the voluminous discovery that would fill numerous bankers' boxes if printed. The defense proposed that a laptop and encrypted hardware would be cheaper than printing copies of discovery documents and could keep in the warden's office. South Carolina Department of Correction inmates are allowed to access to tablets and kiosks for educational resources and some communications, but the devices are strictly regulated. A laptop with a secured hard drive, the defense argues, would make a much more secure method to providing Murdaugh access to his materials. The filings come ahead of a hearing that just scheduled today. Oh, this one's just a very brief one. And also, we know that they are looking for a change of venue. So you let me know in the comments, do you think that they should go ahead and change the venue? Do you think that they've exhausted every possible juror that there could be in their county? And do you think that they should get a new? Do you think that he should move the trial? And they've got a new judge. Oh, I forgot about that. Who is the new judge? I believe he had Judge Newsom, and now he's got Deborah Newman. Okay, so Judge Clifton Newman was the judge that he had before. He's got a new judge. Judge Newman is on civil cases right now. So now he's got a new judge, Deborah McCaslin. So you're going to see maybe I did not see trial number 1. You let me know if you've seen trial number 1, because, each trial judge does things a little bit differently. So that is what we're doing. All right. So thanks for joining us. We are going to head on to court and we are going to begin our coverage of the Alec Murdaugh case. Sorry, my browser is not wanting to cooperate with me, so give me just one moment. and we will begin. Thanks for joining me. Let me know in the comments whether or not you saw trial number 1 or if this is your first look into the Murdaugh case.
I see we have a full house. Good morning. For those of you who've never been to Lexington County, welcome to the Lexington County Courthouse. Are you ready to call? Can you call it? Give it right back to me. All right, we're here for a status conference. I'm going to get the clerk to call the case, please.
In the matter of State of South Carolina versus Richard Alexander Murdaugh, indictment number 2022 GS 15-00592 through 595.
Thank you. All right, Mr. Waters, how are you?
Good morning, Your Honor. Good to see you.
Good to see you. Now, let me ask you, I know some of your counsel at the table, but I don't know all of them. Can you please just let me know who the state's team is?
So I have David Fernandez, Assistant Deputy Attorney General David Fernandez. He's my number 2 in the state grand jury section. I have my boss, Mr. Don Zelenka, who's
I
here.
know.
We have John Metters as well.
I know Mr. Matters.
And then, you may see at various times, we have Assistant Attorney General Walt Whitmire, Senior Assistant Deputy Attorney General Melody Brown.
All right, welcome. Let me, Mr. Harpootlian, can you tell me, I think I know just about everybody at your table, maybe not everybody, but can you introduce the defense?
We support, Your Honor. This is Jim Griffin.
Mr. Griffin?
Bill Barber.
Mr. Barber, good to have you. Okay. All right. I've made some notes on a status conference, and I'll let y'all talk in just a little bit.
She made some notes.
But I want to go over what I want to go over. Because
I want to go over what
sure
I want to go
the
over.
discovery in this case is complete. And I made some notes, and let me tell y'all, I don't know anything about the first trial, so when you tell me something, please be complete when you tell me, because don't assume that I know, because I don't. I want to know about phone records. Do we have all the phone records, and are they complete? Text messages, cell phone extractions, and if there's any supplemental extractions, video recordings, whether there's ballistic firearms, are we complete in that? Fingerprints, toxicology. I think there was a blood splatter expert last time. I just want to know where we are with these discovery items. I'll let the state address that, please.
Yes, ma'am, Your Honor. So we have provided, and obviously provided well in advance of the first trial, a very extensive discovery. I'm not aware of anything in the items that you mentioned that have not been provided to the defense. And if anything, the defense has more than the state does, because a very heavy privilege review was done, for example, on Murdaugh's phone, and formally named an attorney, and that sort of thing. So it's my understanding, complete extractions were provided to them, whereas the prosecution team, the investigative team, only received the privilege review cell phone extraction as it relates to this phone and that sort of thing. As always, we are constantly auditing and looking at everything, but I'm not aware of any discovery from the very extensive productions that were made, not only from just the murder investigations, but also from the very extensive state jury investigations as well. So we have provided those, and obviously I'm not aware of anything in the categories that you mentioned that are not provided to you.
And not anything that needs to be reanalyzed or anything that the court would be waiting on?
At this time, no. Now, as you're aware, and we, of course, sent our responses to everyone last night to this defense motion that was filed late last week. came to the office Sunday to write those. One of those is their request for independent testing on DNA. We put it in our motion, and I actually got an email from Mr. Griffin this morning that if they want to have their defense expert reach out to SLED as to specifically what capabilities they think they have and what they're proposed to do, happy to facilitate those conversations and discuss those with the defense and then with your honor if necessary. Right now, that's kind of where we stand on that. And of course, any other issues that arise along those lines, we're very reasonable and we're perfectly willing to discuss those with the defense. And if there's something that we can't agree on, obviously we'll raise those.
Okay. All right, Mr. Harpootlian or Mr. Griffin?
I want to address everything but the DNA issue.
Right, I'll talk about the DNA later.
So we don't know what we don't know. And I'll give you an example. Let me hand this up to your honor and hand copies to.
I'd wondered if I was going to ask, do you think Mr. Harpootlian is going to grandstand? The answer is yes.
Your Honor, this is a transcript of an interview done with a guy named Chapman and another officer who were folks that arrived on the scene to begin with, processed the scene, and were very involved in the forensics of processing the scene. And if you go to page 6, Chapman, who's in charge of the scene, says this. This is a television interview on March 13th, 10 days after the verdict in this case. He says, in response to the question, I believe he had some help in the aftermath. Or Rutland, yes, Captain Chapman, you know, the disposal of weapons, the moving around a vehicle. We heard so much about SLED and AG's office, they don't have anything. It's all circumstantial. So I pose this question to you. It was a clean crime scene, stage crime scene, clean crime scene. We'd expect to find more evidence or less. And that's what's kind of hard to get people to understand is we didn't find a lot. But why we didn't find a lot? Because it was clean. I mean, it was manipulated. There's evidence removed from the scene. Now, this is 10 days after the trial. This is not what Chapman testified to. And if Chapman has evidence, there were other people at the scene that he had assistance under their theory, or there were other people there. We need to have that furnished to us. And we have other witnesses that testified at trial are saying something totally different, indicating there's evidence to believe that somebody else was at the scene or there were other people at the scene. I mean, this guy's the chief guy in charge of the scene along with Rutland who processed it that night. We need, and we're in the process of doing this to determine if they did another statement or the reports. So we don't know what we don't know. We don't know what we don't have. We need some period of time to try to process that. And Your Honor, I say this, and no emphasis on trying to, we're not alleging that the state has hidden anything from us. We do know there were people that came to see us that said they had important information. We have no ability to investigate. We don't have subpoenas. We don't have a grand jury. We don't have search warrants. And 2 or 3 of those people we sent to SLED. Did they follow up? One had extraordinary evidence about a tie-in between Paul's murder and the murder of a young man named Stephen Smith. But we had no, I can't compel anybody to come anywhere. We sent that to SLED. Did they investigate it? Have they investigated? And I must tell you, there are a lot of pieces of information out there that, and maybe they just stopped once they got the conviction, didn't do anything else, that it's inconsistent with our desire to get a conviction, have a conviction held. So they didn't follow it up. Maybe it does need to be followed up, but we're going to have to go back and look at all of that. We're going to have to determine whether or not additional material developed since the trial. And of course, all of us were shocked by the court's conduct in the trial. I know we were, I know the state was. But it's caused us to go back and look at, and we haven't done a thorough check of it, all the testimony, and read it all, not in the sense of an appeal, which we've done, but in the sense of, I mean, in criminal cases, we don't have depositions. We don't have them here. We have a transcript of every, but not every, I'm sure they're gonna get rid of some of these witnesses that are horrible, for example, right, and get additional witnesses. But most of the witnesses, we have their transcript, their deposition. We need to go back, and read all of that, and we need to get a sense of how you prosecute, like you would in a civil case. So, I can't say that we've got it all. I can't say that we don't have it all. Again, I don't know what I don't know, but I think we will be very diligent. And one of the other things we talked about is Murdaugh's access to that information in a way that makes it convenient for him and doesn't inconvenience anybody else. We'll talk about that. That's another motion. We'll talk about that.
I'll get to your motions in just a little bit. What I really want to know is about phone records, text messages, cell phones, video recordings, toxicology, fingerprints. You have all that discovery.
We're not sure. But we need to review it as if we were getting ready and brand new. I can't, just because we looked at it 5 years ago, 4 years ago, doesn't mean we know we have it. We'll be diligent in doing that, but certainly I would think it'll take us some period of time to review that.
Yeah.
Right. One of the points, reminding me, we did not have OnStar data on Mr. Murdaugh's vehicle until halfway through the trial. That is not the Attorney General's fault. That is, GMC's fault for not furnishing it. We had to do that on the run. We want to go back and analyze that, have an expert analyze that even more. I do want to emphasize the Attorney General got it at the same time we got it. No inference, anything improperly.
Okay.
So that's part of what we need to do. We need to hire additional experts based on some of the views we now have on some of the witnesses, both the state and the defense have. And they need to examine those reports to determine whether we have it. So it's going to take a little bit of time, Judge. I can't tell you today we have everything because we don't know.
Okay. Let me ask you, Mr. Waters, what about the OnStar data? Do you have all of that?
Yes, ma'am. So, Your Honor, we actually SLED had sent 2 search warrants to GM well in advance of the trial, and we're told we ain't got none. And I think what happened was during the course of the trial, we actually had the FBI buy a Suburban and essentially reverse engineer the black box in the Suburban in order to provide us telemetry data, which of course is all provided to the defense. I think when that testimony came out during trial, somebody at GM was watching and they were like, uh-oh. And so in the middle of the trial, I get a phone call saying, about all that OnStar data, actually, we got a bunch of it. We immediately advised the judge, advised the defense, provided that to a usual form. They assisted and agreed to go forward because each hour is curious about what happened yet. So that was nothing with the fault of the state, and we immediately engaged in what we needed to do to ensure the defense had access to all that information. As to him saying, we don't know what we don't know, well, I know my obligations are, and if I have knowledge of something that's disclosable, then it's been disclosed. And so to imply that there's something out there, I mean, we're always constantly auditing that and doing our obligations, but I take discovery obligations very, very seriously. Our group knows that. As far as these musings, I haven't watched this TV interview of musings of some captain about, whether the scene was clean. Well, there was evidence presented at trial that there was standing water on the concrete pad of the kennels, that the hose was not put back the way that it normally was coiled by the person who was in charge of taking care of those kennels. So he may have been talking about that, but ultimately, while Colleton responded initially, the scene actually was in charge of the process. SLED, and they've had access to all that information. So to sit here and imply, we don't know what we don't know, well, I'll recognize that, but I know that my obligation is to provide that information to the defense, and if I'm aware of it, then it's been provided. And we have done that. They've had it well before the original trial, and we will continue to do that. And as he freely recognizes, the OnStar data came in late despite our best efforts, and was immediately disclosed to them at every opportunity to process that information, and then they agreed, you know what, let's continue on. So that's not anything, any sort of indication of a bad process or practice.
So the bottom line is they have everything that you have.
To my knowledge, yes, ma'am, and we were very careful about going through all that discovery.
And you don't know of anything else that needs to be analyzed at this time.
Well, again, we have that DNA.
The DNA, and I'm gonna get to DNA in just a moment.
Of course, it was analyzed ahead of time. Now, what they're
Right.
talking about is some additional capability, and as I expressed in our motion, and Mr. Griffin has responded, I'm happy to facilitate discussions, and if there's some capability out there that's beyond the capability of SLED, and it has a reasonable chance of providing some sort of analysis, then we're happy to do that. Now, of course, as we put in our motion, ultimately, there's absolutely no evidence that Maggie Murdaugh was in a struggle with anyone, that she had any sort of defensive wounds, that she was scratched, any sort of attacker. And we also know that it's very common how sensitive touch DNA is. We're constantly shedding DNA and picking up DNA from others by shaking hands and doorknobs and all the rest of it. So, this is a bit of a red herring, but that doesn't mean that we are not willing to discuss with the defense anything that they want to do, and if reasonable, we're the first to do that. And if that needs to come back to this court, we'll do that as well.
Okay, thank you. Sure.
We know from testimony in the first round that the chief SLED officer involved admitted he misrepresented things to the grand jury. Since the trial, the case was dismissed, in which he testified because the judge found he was hiding evidence and misrepresenting that. That's the chief officer. No longer SLED, but it raises questions with us, not whether it's been withheld by the state, by the prosecution, but did he give them everything he had? Did he do what he did in the subsequent case after the trial where he had evidence? And I think we've got to go through it and look and say, are there gaps here? Are we missing something? And for us, and look, we want to try this case as quickly as possible. No question about it. But what we don't want to do is not be prepared based on what we now know happened at the first trial. And we'll have a motion probably next week that will expand on that a little bit. We didn't feel that we wanted such a motion.
Well, and I don't. I really wanted to go over and see where we were with discovery. I want to set a timeline. I want to set out some pretrial conferences, and I want to set a trial date. That's why we're here today. And I want to go over some of these motions. I think some of them are not substantive that I could go ahead and rule on those today and be done. And I will set up a pretrial. I'll give y'all some dates and hope you brought your calendars. And we'll set a pretrial. I don't know that one pretrial is going to do it for this case. We'll probably have several. And that's fine. The court's amenable to anything that y'all need. And happy to hear what you have. If you find something, Mr. Harpootlian, that you need to bring to the court's attention and you want to file a motion, I am more than happy to hear it. Okay? All right, so let me move on to my next notes. And we've kind of touched on it a little bit. Experts. Do you know how long? And the reason I'm just asking is because I do want to set a trial date. Believe it or not, overnight when I was assigned this case became the oldest case on my docket. And anybody who knows me knows that I will move an old case. And I intend to do that with this one. So I'm asking Mr. Waters, expert witnesses, do you know how long you need to get expert witnesses and talk to people and get everything that you need for the prosecution of this case?
Yes, ma'am. So the vast majority of our experts will be the SLED. So I think that, we are ready within reason, of course, to move this as expeditiously as possible. We do have another expert that testified from the FBI and things like that, but much of that is the same. And so as far as the state's position as to scheduling, and I know we've already sort of stated this publicly, that we were trying to do this, before the end of the year, like towards the end of the year, we're ready to go. So I'm not aware on the state side of any expert issues that provide for additional delay.
All right, Mr. Harpootlian, how about for the defense?
John, we have 8 expert witnesses. All of them are new. All of them are just beginning to get the information they need. The DNA, when we are told, may take up to 6 months. It is, unlike what's been represented by the state, critical. And Mr. Griffin will address the specifics of that in just a moment. But to try this case this year, these guys are talking about going to the death penalty 4 months ago or 3 months ago. Try it before the end of the year cannot be done for us to be adequately prepared. And we talked about the laptop. Without the laptop, we can't try it next year. If we have to go down there and take in a banker's box at a time to read documents, almost 20,000 pages of documents. So we came up with a way to expedite.
Well, surely, Mr. Harpootlian, he reviewed those before his first trial, did he not?
5 years ago. I mean, it's just a judge. I can't remember a case I tried 3 months ago when the materials on that. I mean, it's ridiculous to require him, not with all due respect, to require him to have a memory of each document that he looked at almost 5 years ago. And by the way, our solution to that, contrary to what Mr. Waters put in motion, is ironclad, no chance of it being distributed. We'll give them a laptop that's encrypted, that since there's no attorney-client on it, corrections can look at it, SLED can look at it, anybody can look at it, and let him look at that without us having to take hard copies of stuff down there and review it with him. Can't leave it with him under the court order. In other words, you just can't take him to discovery and leave it. There's a court order prohibiting that. And I'm sure the warden does not want boxes and boxes of stuff sitting in his. But if we have that, and he could be reviewing these documents and experts as we're reviewing them. I mean, let's not forget, he's a lawyer. Now, he's a disbarred lawyer, but he has probably more trial experience than many of the folks on either side of the court. So he understands what he's looking at much better than any client I've ever had. So I think it's important, if you're going to try to expedite this, for him to have, and we can talk about the laptop separately, but that's going to be a condition. It's going to take us at least 6 months to get these folks retained, have them look at the adequate material, look at the state's testimony the first time around. And of course, if they have a change in who they're using or taking a different approach, we need to know that as soon as possible. I would point out that they were giving us discovery in the last case after the first week of trial, in the second week of trial. So we can't have that happen again. They say they got it all. We're going to assume we have it all unless they want to supplement it. They supplement it sooner rather than later. That allows us to expedite. I mean, I think what we probably ought to try to do is figure out a trial date and then back up from that. What we're comfortable with is late spring, early summer next year.
Okay.
We can live with that. Given, I mean, if we have to go down there, one of us has to go down there 5 days a week, and you know, we're incarcerated, I want to announce it, it's 2.5 hours from here. It's a half an hour to get in. So before ever you see it, it's 3 hours. And then you only have 3 hours with them, and then it's a 3-hour trip back. That's why the laptop is so important.
Okay. Mr. Griffin, anything you'd like to add as to experts?
I have been in contact with the DNA lab in Houston. I can talk more about that. But when I mentioned that, they were asked, how soon do you need it? And I said, well, hopefully we're looking at a spring, early summer trial date. And the answer was, well, we need to put a rush on it. And I can talk more about the lab if Your Honor wants to hear it. I mean, they are the.
I'll get to the DNA in just a minute. And then we'll go forward on that. All right, let me talk about this computer at the Department of Corrections. I did receive your response, Mr. Waters, yesterday at 5. Did you get the opportunity to look at that, Mr. Harpelian? I mean, basically, I just made myself some notes. You were concerned about the state grand jury material and talked about a protective order and some other issues. I agree about there are some sensitive issues. The state grand jury material is protected and should be protected. And then you mentioned an order that Judge Newman had. I kind of think, Mr. Waters, that when this case was reversed, that order goes out the window and we might need a new order for this case. It's my understanding that the order stated that the grand jury material is secret. And I mean, that's pretty straightforward. And I know that you would like to prohibit the digital dissemination of the state grand jury material, that there's no photocopying, scanning. I breezed through this. You don't want any digital copies. And all of this, while it doesn't prohibit the defendant from reviewing the case materials, you want the attorneys to make sure that they keep in their possession the state grand jury material. Is there any objection to that, Mr. Harpelian?
Your Honor, the issue of that is what is the state grand jury material? I think, we can designate what that is. It's beyond grand jury testimony, there's very little of that in the discovery. I think they've gotten things through grand jury subpoenas that have been produced, underlying records and whatnot. And so, is that really sensitive grand jury material? And some of us introducing evidence at the trial, I'm sure of that. But so no question about grand jury testimony. We have no issues with that. But it's just hard to say what exactly are grand jury materials when a lot of the subpoenaed documents and information have been produced.
And Your Honor, the issue is dissemination. I mean, he has a right to read.
Oh, absolutely. I said that. It does not prohibit him from reading it.
Issue is dissemination. I mean, we're just basically talking about a big Kindle. You can read on it. You can't send email. It's not connected digitally or cell or Wi-Fi to anybody. It can be kept. Let me say this: the Department of Corrections has been extraordinarily professional in dealing with us, giving us access to that. But no complaints with them whatsoever. But what we'd like that laptop with the warden and corrections to have total access to it. It can be inspected by SLED to make sure it can't transmit an image, a message, can't be used in any way. There is no Wi-Fi at this particular institution, so it has to be by self-service. And these are not difficult technical issues. And if they're concerned about grand jury testimony, we have to take that out. That's a 1% of what we want them to look at. And we can certainly do that separately with hard copies. We'd have to go down there and do that.
Well, let me tell you. Well, Mr. Waters, let me hear from you first.
Yes, ma'am. So we really, as far as the protective order, we really have two things. There was the state grand jury investigation, and ultimately there was the standard protective order for that. He's pled guilty to all those offenses. There's nothing to be about that. Necessarily, as that state grand jury investigation was going, things came up that were ultimately relevant to the murder. So it's much bigger than they say. You know, I don't have the number in front of me, Your Honor, but it was at least 20 witnesses, multiple subpoenas. And so all of this was in that ambit. And as well as Judge Newman issued a second, to my recollection, protective order as it related to just sort of the murder evidence as well. So they're two separate things, but they all blend together. And so all of this evidence is sensitive. On top of that, the murder evidence is in fact very sensitive. And frankly, we've been trying our best to protect it from improper dissemination because it's worth a lot of money. Now, one thing SCDC is adamantly opposed to is having an inmate have a laptop. They are absolutely 100% opposed to that. And I have to remind you that this is an individual who already had his tablet privileges taken away from misuse of that. This is an individual who was caught receiving contraband that was passed from a family member who was offense to him. And so this is not a guy who is, and this is also a guy who's been convicted of over a decade of fraud. Now, they say that these things can be locked down and I understand these issues very well. As the state grand jury made a point to partner with SCDC to fight the problem of fraud and corruption emanating from there, and it's done with the use of devices. This is a very severe security issue, and no matter what protections are put in place, there's always ways around this, and SCDC has experience with that. So the fact remains is he's an inmate, and SCDC is adamantly opposed to there being some laptop that he has access to. And for this idea that SLED is going to be able to review, attorney communications and work product on that, I don't understand how that's going to happen. Now, SCDC is happy to accommodate the defense and to any meetings they have. And no one says that the defense can't bring down digital evidence to review with them while it's under their supervision and then take it with them when they leave. That is absolutely the way it should be, that ultimately this information, whether state grand jury or not, is too sensitive to have an inmate, despite what protections are put in place, have a laptop, because frankly, the reality is inmates are constantly and successfully violating whatever protections are put in place. Despite everyone's best efforts, you're doing a great job. It's just the nature of it.
Okay, sure.
I had a series of emails, and I don't see the Department of Corrections here today objecting. I had email chain with the warden at a particular institution, and he doesn't raise those objections. He just, and we bring another laptop and can't have cellular or Wi-Fi capabilities. So, and that's what this says. So, and with all due respect to the Department of Corrections, if you don't get the ability, I mean, if Mr. Griffin and I, or Mr. Barber, or Ms. Fox have to go down there, 3 hours down, sit with him for 3 hours, 3 hours back, we're talking about at least the end of next year, not the beginning of the following year, to get this support. We can't be working on experts, and we can't be interviewing witnesses while we're tied to sitting there and babysitting him while he's reading a laptop that doesn't have any capability to communicate or copy. And we'll be happy to have SWED inspected. We'll be happy to have the Department of Corrections inspected. But, the idea, we bring laptops in. We were given, as you can see, permission to bring laptops in. Laptops are brought in all the time. The question is, can he keep, not he, but can the warden keep it, or some office at the institution keep it and give it to him when he needs it? And Your Honor, I gotta say, the idea of bringing him in here chained up, the idea of not letting him have access to a laptop, the idea of opposing everything we're trying to do to expedite this process. I understand it's Mr. Waters' job to legally prejudice the defendant, but this is beyond the pale. This is beyond the pale. I'd ask you to remind Mr. Waters that he has an ethical duty to see that justice is done, not to get a conviction. Thank you.
Mr. Harper,
I don't.
And that is,
Okay, we're not gonna go there, but you,
and I have no intent to prejudice anyone. Prejudice suggests a decision on an improper basis.
And the court doesn't take it that way, Mr. Waters.
Thank you, Your Honor.
All right, let me tell both of you, I took the liberty of calling the warden and talking to him about the laptop situation. And because I too used to practice law, I remember terabytes of discovery that I had to carry to my clients to go see. And I know that it can be cumbersome, and I would imagine the discovery in this case is a lot. How many pages do we have, Mr. Waters?
It's very extensive. It's half a terabyte.
Half of a terabyte, okay. I talked to the warden. He will not allow a laptop. And for safety reasons, he said he would, quote, make available a conference room. Council may bring their computer. They could have a law clerk come, or the attorneys could come themselves. They could look at it. He could review his discovery. They could bring their own laptop. However, somebody must be with him. His concern was having a laptop in his cell. No other inmate has a laptop in their cell. They do have access to an iPad that has Westlaw on it. Now, I just have to be honest with you. I didn't even think about asking him if you could download any discovery on that iPad. I don't know if that's available, but I certainly will call and check and see if that's acceptable to him. If that's the case, I'm going to have Mr. Waters draw me up a proposed order on the state grand jury material. I haven't looked at Judge Newman's yet, but I will. Please run that proposed order by Mr. Harpootlian and Mr. Griffin. I will check on the downloading on an iPad, but I'm not going to allow him to have a laptop computer in his cell. It's for safety reasons. That's out of my control. I think it's not only for the safety of the others at the institution, but probably, Mr. Murdaugh, for your own safety. Okay.
We're not proposing he have it in his cell. We're proposing that the warden have it and give it to him to go to a conference room, if he's good with us, to look at it there. Does that make a difference?
Well, I'll ask him. But when I read your email here, this seems like he could go to his cell. He could keep it in his cell. I know good and well that the warden is not going to allow that. I talked to him personally. Okay. We'll follow up on that in our next pretrial. Or if I can, I'll probably let you know before pretrial, but if he says no and it's for security reasons, then the answer is no. I'm not going to allow it. You understand, Mr. Harpootlian? Mr. Waters?
Law clerk or other person, paralegal?
He'd let a paralegal go. All he wants is the name of the person, and you're more than happy. And he said he's not going to limit you to 3 hours. They can stay 8 hours if they want. He will make a conference room available so he could see the material. It does not have to be a lawyer. Okay, that.
Your Honor, I spoke with the director of Federal Counsel this morning, and they expressed the same thing. We're here to facilitate the defense doing that.
Right. You know, I want him to have all his discovery. He's entitled to all of it. You know, it's safety concerns. It's. If you can have a law clerk or a paralegal go down, then you're satisfied, Mr. Harpootlian, that'll help you out?
Automatically, if we're not limited to 3 hours, it makes that 2.5 hour trip down and 2.5 hours back worthwhile.
Okay. Well, then I will verify that and send y'all an email tomorrow on that. That's okay. All right, perfect.
Thank you, Your Honor.
All right. Now, let me go through. I had a motion filed for the defense, and I just want to put this on the record. The defense wanted the defendant to be unshackled in the courtroom. I received a response from the state. They objected. Then I had a response from Mr. Harpootlian where he withdrew that motion. That still stands, Mr. Harpootlian?
Yes, Your Honor, although we may renew the motion, the reason for this is potential jurors are watching this right now. It's going to be, wherever this goes, it's going to be difficult to get a jury. And to the extent that parading him around in a jumpsuit shackled like an animal impacts their view, it's going to make it more difficult for us to get a jury. Now, again, Mr. Walter's argument is specious. He's not dangerous. The only thing he can be convicted of is stealing money. Now, Judge Newman let him come to the courtroom in street clothes and unshackled. I know Mr. Waters feels compelled to get every advantage he can, but this is one that prejudices our ability to get a jury. So I would ask that he be allowed to come in the courtroom unshackled in, I will call them street clothes. Now,
So are you renewing your motion now? Just want to make sure.
what I wanted you to see today is this. I mean, chained around the waist, chained to the hands, chained on the feet. I mean, this guy is not a serial killer. He's not, Ted Bundy.
You could sit down, Mr. Murdaugh.
And always convicted. He's accused of killing his wife and son. But he was accused of killing his wife and son. And Judge Newman allowed him to come unshackled in his street clothes every hearing we had.
All right, Mr. Waters, I did read your response, but I'll be happy to hear anything and I'll take it under advisement.
Well, again, they withdrawn the motion and now they.
Now they,
This goes back to, it's not the state's fault. He's an inmate serving a 27-year sentence, okay? This is, again, SCDC's policy for non-jury court to be dressed out in restraints. He's not only facing 27 years, but an additional 4 years in federal court, and he's also indicted for a double murder. So this is a basic security consideration. Again, the intent is not to prejudice anyone. The intent is the security of every time someone is transported out of court. It is a security risk. And the first two goals in any escape attempt is to become unrestrained and in civilian clothes. So I'm here to represent what is basic policy and procedure for inmates serving long, felonious sentences with SCDC. I completely understand that we have a jury, the calculations are different, and that is going to be a different thing to do. The remedy for all of that ultimately is our process. It's going to be jury selection, and it's going to be instruction from the court, which the jurors need to follow, and which I know our citizens can.
okay, thank you. All right, I'll take it under advisement and I'll issue an order on that. Let me move on to the DNA. Again, I just received the state's response yesterday at 5 p.m. I read it, and I'm going to save it for the next pre-trial because this is what I want to know. I'd like to know how long, Mr. Griffin, it's going to take to analyze exactly what it is you're asking for. And I believe it's genetic.
Yes, Your Honor. And the state's response says, give us somebody to talk to at the lab.
Okay.
So
And
that was conveyed to them this morning. The CEO of Othram's name, email, and telephone number. They have received the VP of Law Enforcement Division at Othram, his cell phone number, and the client intake person that we use now, that I've been interfacing with, and they will be better able to answer specifically how long it will take. We've agreed to pay for it, and just background information.
I'm gonna let you pay for it.
Yeah. And these murders happened in 2021. We're in 2026. 2021, there's no such thing as artificial intelligence. In 2021, this genetic genealogy was just on the ground floor. In 2026, we are light years ahead. And so what we're asking for didn't really exist in 2021. It does exist today, and Othram is the leading lab that performs this analysis. They did last year on 2024, the statistics are that they cleared 200 cold cases on behalf of law enforcement around the United States and the country. They work with law enforcement every day. The most high profile case they did was at the University of Idaho, the Moscow, Idaho murders that took place about the first week of our trial. College kids were massacred in a house at the University of Idaho. They had a DNA sample they ran through CODIS. Came up nothing. There was nothing. The state of Idaho Police Department, like SLED, had a contract with Othram. They sent the test Othram. Othram does this genetic genealogy DNA analysis, and it comes back to a family member who'd done a DNA test, ancestry test, of the person who committed these murders, Brian Koberg. That's how they solved the Moscow murder cases, was through Othram lab. The difference between, and they say they don't have enough samples to get through CODIS, and I've talked to the lab about that, and that's not an issue. CODIS uses an analysis called STR. This analysis is SNP, and they call it SNPs. CODIS has 20 data points. SNPs has 500,000 data points that they analyze. Now, it takes a while to do that. And so, we're gonna have to see what the lab says. They've asked me to get information from SLED as to, they'd like to see the electropherogram or mixture proportions so they can have a better handle on it. And I'd ask Mr. Waters to give us a name so that these experts can interface. But what they're doing in Houston, Texas, they don't do in South Carolina at the SLED lab. There are handfuls of labs around the country, and they are, they're certified. They work with law enforcement. I don't know that they've worked specifically with SLED. They're familiar with SLED when I spoke with them, but they have a whole division.
So you need an expert's name or whoever has this sample to see if there's a viable sample that you can send, that they
Correct.
could send.
And they can work with the extract that SLED used when they did their STR analysis. They
Okay.
can work with that out there that they told me, but
Mr. Waters, can you give him a name so he can move forward?
That's what I put in my motion, Your Honor, is please give us a name, and I'm happy to have SLED reach out and talk to them about what their supposed capabilities and proposals are and any procedures. And I'm then made privy to that information. I'm happy to discuss those with the defense. If for whatever reason we can't agree, we'll come back to Your Honor. That's precisely what I put in my motion is let's talk to, let the experts talk so that my experts can hear, what it is that they propose to do. And I'm happy to do so.
and I gave him 3 names and contact information this morning, and I've asked a name that I can send back to my folks. I do want to address this red herring argument. The DNA that we're talking about, Your Honor, came from Maggie Murdaugh's left fingernails. That was tested by SLED with this STR analysis. The DNA sample number 70 that we're asking to be tested, it positively was not Alec Murdaugh. Any of the other folks who they took buccal swabs from went through a long list, not them, except for one potential. And that potential, the ultimate result was it's 11 times more an unknown male, so they know it's a male, than it was this person. That's how they do things in their DNA analysis. And Mr. Waters said, well, there's no evidence of struggle, but there was a shell casing under Maggie Murdaugh's body from the gun that killed her. I mean, that shell casing and that gun had to be in very close proximity. Maggie Murdaugh's cell phone was missing from the crime scene. Was DNA transferred at that point in time? And so we don't think it's a red herring. We think it's very important. Now, it may turn out to be, innocuous. We don't know, but it's worth looking into.
Okay, I haven't said no. This is what I do want you to do though, Mr. Griffin. I want to know how long it's going to take to analyze what it is that you're asking for. And even if I expedite it, I'd like to know how long it's going to take. And I'd also like to know if there's even a viable sample that they can get. And we will discuss this at our next pretrial. Anything, Mr. Waters, you're going to give them the name of the person that SLED that he can get in contact with. Let's see if there's a viable sample.
And the lab has told me if there's not a viable sample, we'll tell you that. But
Right.
they work with a lot less than.
Okay. Well, let's start with that. Let's make sure we get a viable sample, and then we'll go forward. And we're going to go forward at the next pretrial. I promise you, the pretrial is not going to be that far away. All right. Let me move on to the motion for change of venue. The defense filed a change of venue motion. The state has not had the opportunity to answer yet. So I'm going to give them time. In the meantime, before our next pretrial, if at all possible, if y'all agree on a change of venue, please give me some suggestions if y'all can agree on it. If you can't, make your own suggestions and then I will decide for you if we go that route.
Even in spite of the acrimony here today, the lawyers have been able to talk to each other, and we have already talked about this. I think we'll have continuing discussions, depending on when you set your next pretrial.
An answer for me?
Try, if I don't have to keep driving down.
Yes, Your Honor. Of course, without taking a specific position right now, I
Right.
Mr. Harpootlian this morning that, we can kick some things around. And like you just said, if we agree, great. If we don't, then we'll work with each other.
That's right. Don't have a problem with that. Okay, perfect. All right, now let me address, I see Mr. McCullough sitting out there, and then I also have another, they're both the same protective order, but they're wanting two different things.
Ours is not the same as this.
That's right, they're two different things.
Barbara will address on it.
Right. As far as, but I think before we go there, Mr. Harpootlian, I believe, Mr. Waters, am I correct in stating that you're working on a response to both of these? There might be some redactions that you wanted, and you're going to submit that to the court? Okay, and I'll be able to address that at the next pretrial conference.
Again, we are generally in favor of those being unsealed, but they will have to be done judiciously and with appropriate redactions to preserve their identities.
Right, because I did, yeah, and I did receive something from SLED, an email from SLED.
General Counsel Adam Whitson is present here today, and Sledge.
Where is he? Okay, I did receive your email, and just get me an answer on that, and we'll decide at the next pretrial then. Okay, those were all my bullet points. So let me ask the lawyers, did I miss something? Is there something you would like to add?
One thing Your Honor had mentioned is the location of pretrial hearings. And from the state's perspective, we're happy to come wherever Your Honor happens to be.
Okay,
Your Honor, we're more than happy to come wherever you are, although this production of these hearings might not dictate, but certainly suggest you come to a venue like Washington County, where there's plenty of room and you have an extraordinary program that's accommodated everybody.
I think they've done a really good job with security and with the press and being organized. And this is my home county. Let me just ask and throw this out there. Mr. Waters, is there any objection if we hold pretrial here? The reason being, we have a big courtroom. I already have security set in place. I think the clerks and both clerks and security have done a really good job. This is not the only courtroom in this courthouse, so I won't disrupt holding court in Lexington, which I would not want to do to any county. Sometimes I go to really small counties and I don't think it would be good to hold a pretrial there. Does it suit?
I mean, from the state's perspective, and again, being a longtime AG, I've been in pretty much all of them. And as an AG, Lexington is like a second home, obviously.
Convenient.
Office, solicitors, office, law enforcement, the court, of course, is very accommodating here. So this is certainly, I think, would be of most convenience for parties as we get ready for it.
Okay, it's not far for anybody to travel, Mr. Harpootlian? Okay, and I will try to make sure that when we arrange these pretrials that we will try to be here in Lexington. Anything else, Mr. Waters?
I believe that's it from the state.
Defense?
Your Honor, that's all we have, but if we could talk about that schedule for the next pretrial.
Oh, I'm getting ready for it right now. Let me tell you what I have. I've gone through my calendar. And so it's hard to get lawyers together, especially when I have this many lawyers. So let me throw some dates out to you. August the 13th and the 14th. July 29th, the 30th, or the 31st.
Your Honor, so in chronological order, the first would be
July 29th.
I'm scheduled to be out of state with that, from the 29th through the 31st.
Okay, then let me move on to August 13th and 14th.
Your Honor, we have a mediation on the 13th. The 14th is available.
14th works for the state, John.
August the 14th it is. That will be our next pretrial. Now, with that said, I'd like to have all motions by August the 7th, if I could. I like to read my motions. I like to be prepared. So if I could have your motions, I understand that some of them are late. You might think of something at the last minute, that's fine, but please, please don't file something at 10 o'clock at night and expect me to rule on it in the morning. Okay?
I apologize for those coming in late. We had-
No, you're fine.
I came into the office just to make sure we had something out there.
Mr. Waters, you're fine. I was not planning on ruling on those motions. Now, had I been, I might say something different. But please don't do that to me, okay? Now, let's talk about a trial date. The only other information I would like to know is how long this DNA is going to take. I would like to know that, but I'm gonna tell y'all, I'm thinking April the 5th. And this being, I'm trying to get through Easter, and I know how hard it is to pick a jury when you've got spring break. That's usually right before Easter. It is the March. Is it the 28th? I think it's the week. It's March 28th. So I'm thinking April 5th. I know that we'll have a new attorney general coming in. Y'all, Mr. Harpootlian has already told me it's going to take 6 months to get experts prepared and ready to go. That would give the new attorney general time to look at his case in case he's going to be here and join us. And let me tell you this, tell both of y'all, I think y'all know me pretty well. When I set a trial date, I don't do continuances. I don't do it. It better be a really good reason. So, how does April the 5th sound, Mr. Waters?
Yes, that will be ready.
Mr. Harpootlian?
We'll be ready with some contingencies if the DNA takes longer, for instance, or,
I will have that information by next pretrial. If I need to extend it out a couple of weeks, I will, if that's the case. Please do not think that this case is going to be tried a year later, because it's not. We're going forward.
more than happy with that. Mr. Murdaugh is more than happy with that. I just, again, DNA, all, everything, like, because the science in all these areas is much better than it was 5 years ago.
I understand technology changes overnight. Overnight, I understand. Mr. Griffin, anything you'd like to add?
Yes, Your Honor. The Supreme Court reversed this case on misconduct by clerk of court. But the Supreme Court also addressed financial crimes evidence. And depending on how much of that or any of that comes in, will determine the length of the trial in many respects. So Judge Newman last time would not rule pretrial on that issue. And it is going to be an issue that we're going to have to brief and argue with Your Honor as to, we don't think any of the financial crime evidence should come in at trial. And so I'm just flagging that it would be helpful to us, I believe, and to know if we're going to have to defend against that during the trial, or are they going to be able to put it up? And so I'm just asking maybe some earlier date where we can have, Your Honor, address those issues.
We will. I'm just going to tell you, I like to address all pretrial matters beforehand, because when I say April the 5th, we're picking a jury and going forward. All those issues should be decided by then.
Well, we filed extensive pre-trial motions prior to the prior trial, laying all our cards on the table. It's exactly why we thought that was admissible.
Thank you. I appreciate it. Anything further before we adjourn, Mr. Waters and Mr. Harpootlian?
Nothing for the defense.
All right, perfect. Have a good evening.
Wow. Wow. Oh my goodness gracious. Wow. Oh my gosh. I am blown away. I have so many notes. I have so many notes. I don't even know where to start. Okay, first of all, this judge, wow, she is amazing. Isn't she amazing? She is so amazing. Now, again, I did not watch the first trial. I don't know anything about Judge Newman, so I'm not going to even go there, but we're going to compare her to other judges that we've seen, right? We are seeing a lot of really great judges coming out. It is refreshing. It's great. And now I also have to say she's probably under a little bit of pressure, right? She's in a pressure cooker. This case has already gone to trial. This case was overturned. So the eyes of the state, the eyes are upon this judge. And I bet you she's a great judge in general, but I bet you she is taking extra special care with this one to make sure everything is done by the book so it doesn't come back again. So, wow, super amazing judge. I already love her. I already love her. When she talked about she was a trial attorney, and she knows about the terabytes of data. She knows about how long it takes for XYZ, and she's trying to accommodate everyone. Now, in this world, you're not going to be able to accommodate everyone, and something's going to fall through the cracks, or someone's going to be upset because things didn't go the way that they wanted them to go. But she's doing her best to make sure everybody is happy. So I'm beside myself with this judge. It's going to be fabulous. Now, I also have to say that I did not watch the first trial. I heard smatterings of some things here and there, but wow, if you want to talk the comparisons between Alec Murdaugh and some of the stuff that he has going on and the Karen Reed case, they are very similar. Why? You've got the defense spouting off that the police SLED didn't do what they were supposed to do. The SLED agent said that he lied to the grand jury, and then of course the prosecution's like, no, he didn't. So there's that. Then they're talking about evidence. Was evidence manipulated? Was evidence not given? That's one of the persons that they want to talk about was SLED, that did he hide evidence? Did that guy hide evidence? Well, who does that remind me of? That reminds me of Michael Proctor. Michael Proctor may not have hidden evidence, but he certainly didn't give it over to them, right? In Karen Reed's case, the discovery was like piecemeal. For example, the Sally Port videos, right? If you know, you know. Let me know in the comments if you know about this. So when Karen Reed's team was going through trial 1 and then trial 2, remember she was tried twice, that they were just getting pieces of the video. And they were like, why are we getting pieces of this video? Where's all of the video? And they're like, oh, it's motion activated. No, it's this, no, it's that. And they just, like, the prosecution just kept making excuses for why this video was the way that it was. Why is it inverted? Why is this time cut off? Where is this time? And they kept just like making excuses as to why that this was the way that it was. And it turns out that there was more video that they didn't get. And you just sit back. Now, mind you, Karen Reed was acquitted of her charges, but let's say she wasn't. And she went to jail, right? And then they got all this evidence afterwards. You think Karen Reed's case would have been appealed and turned over? Oh, you bet it would have been. But here's also the other thing, is that the defense kept screaming from the highest heavens, Your Honor, we don't have the discovery. Your Honor, this isn't right. This isn't right. And I believe Judge Beverly Cannoni did the best that she could, but it's possible that she could have done more. But we'll leave it at that because it is what it is. We can't go back and change anything, but we can talk about it. This is where we have the conversations where we talk about it. So, did he hide evidence? We don't know. Is that just Dick Harpootlian grandstanding? We don't know. But I'll put a pin in it because it may come back up again. But we'll see. Does that excuse whether or not Alec Murdaugh committed these murders? We don't know. But this case is being tried all over again. So all of the stuff that happened in the last trial probably won't come in this trial. But what will come in? So they're talking about the financial crimes. That too is a huge thing as to why it was appealed. And they're going to go over that, what's going to come in, what isn't going to come in. And that is where the pretrial hearing motions will come about. Dick Harpootlian, I talked about him grandstanding, and he kept saying, Your Honor, we don't know what we don't know. Well, that's true. And yes, you have to go back and review the evidence, but you know a lot of the evidence already. So it's not like there's going to be some new revelation that's going to come out that's going to change everything, right? except for the DNA, and we'll talk about that in just a minute. All right, so did he hide evidence? They're just beginning the DNA evidence. We'll talk about that. Oh, the death penalty. So it has been rumored that they may want to have the death penalty in this case. If they do, that changes the dynamics of things, right? It's going to, if you have a death penalty case, it's almost as if you're doubling things up. And if this is going to be a death penalty case, will they need more time? The answer is yes. Will she have to give them more time? Yes. I know she says she doesn't like continuances, but a death penalty case needs more time, right? So that's got a pin in it as well. They talked about the computer. Should Alec Murdaugh have access to a computer? There's so many terabytes of information and there's so many documents and they don't want to bring the documents and it's 3 hours there. Well, is it harder for people who are convicted of a crime, who are in jail, or those who do not have bail, to review their evidence that they have? The answer is yes. Inmates, it's harder for them to review all the documentation, etc., because they are in jail. They sometimes don't get to keep their documents in their jail. They only get a certain time frame to review their documents. As stated earlier, they only have 3 hours to do it, but then now the warden says you can have 8 hours, but they have to have somebody go and sit with them. So it could be a paralegal, they said, but somebody has to be paid to sit with them to go through their evidence. Is he going to get a computer? I bet you the answer is going to be no. He's not going to have a computer that he can go to a room and go look at or what have you. And as Mr. Waters stated, he had an iPad. He abused that iPad, did something with contraband. I don't know the smatterings behind it. If you know, let me know in the comments if you know why he got his iPad taken away. But he obviously did an end round and did something where he got his iPad taken away. So he abused the privileges or found a way around it and used it to his own benefit. So will he get a computer? I don't know. Doesn't sound like it. But they're going to revisit that. All right. Let me continue. Trying to read what I wrote. Yeah, contraband. So then they were talking about whether or not Alec Murdaugh should be coming in chained, and should he be in his street clothes? He's a convicted felon, right? He's convicted of the financial crimes, right? He's in jail for the financial crimes. You are a prisoner. So some people are like, well, that's inhumane, or it looks bad for the jury or whatever. Well, think about this. It is easier for the law enforcement who have to handle his transportation, right? He's in his jump clothes, he's already chained up, and he just moves from one place to the next. There isn't anything extra they have to do. If he's unshackled, I love he's shackled. If he's unshackled and he has to go into his day clothes, that's another step that the law enforcement people have to do. So it takes time. It takes time to transport him. It takes time and security measures to get him from one point to the next point. Then there's security measures to unshackle him, put his clothes on, either reshackle him or whatever. So these are extra resources, extra time, etc., that the security people have to maintain and do each time he has a hearing, whatever. Most of the times, prisoners who are going through these pretrial motions are shackled, or the shackles come off. Maybe take off the arm restraints while he's in his hearing. I don't think that's a big deal, but I understand Mr. Harpoolian's grandstanding, whatever. It's fine. All right. can SLED look at the work product that's on the laptop? No, because it's attorney-client privilege. They can't do that. That's another extra layer of security and stuff. I don't think he's going to get a laptop free access by himself. The judge made a good point. What about the iPad? Can there be some stuff downloaded on the iPad? They have something called Westlaw or something like that. That was a good point she made. I like that. I like that this judge is really, really, really into this. Okay, judge, he's entitled to his discovery. She agrees with that. That's what she said. He is entitled to his discovery. Now, how he's going to get that, I don't know. They'll have to figure that out. And I love that Harpoonian said that he is not a serial killer and that he is not Ted Bundy, so he shouldn't be shackled up. But, Your Honor, he is a convicted killer, or, well, sorry, my phrase. He is a convicted felon of his financial crimes. And when we talk about serial killers, some people, this is a controversy in itself. Some people say if you kill more than one person, isn't that a serial killer? It doesn't have to be one person one or more persons at a time or a different time. For example, even in Kohberger's case, people said that he's a serial killer because he killed 4 people. Let me know in the comments what you think. It's not a hill I'm going to die on, but just FYI. So it just popped into my mind. So I wrote, he's a criminal. I wrote that. He's a criminal. He was convicted of his financial crimes. And it's a security risk, right? It's a security risk if he runs away and he's in his civilian clothing. Well, please tell me that if by chance Alec Murdaugh were to be in his civil clothes and he runs away, he's an escaped convict, you can't tell me that people are not going to recognize this 6-foot-something man who has very light hair. He is a very distinguished person. You would be able to recognize him. So I don't think he's going to get away with, what was the Harrison Ford, Richard Kimball movie where he escaped? It's not going to be that. All right. All right, let's talk about the DNA. I told you this earlier. I talked about this earlier. So there was DNA found under Maggie's fingernails or whatever, right? It was touch DNA. I'm not sure what kind of DNA it is, but anyways, they have DNA. And typically, all the evidence is in the custody and control of the prosecution, right? The investigators, SLED, whomever, FBI, whoever is investigating the crime has the evidence, especially DNA evidence. And typically, they're the ones that analyze it, and then they give the results off to the defense. The defense has an expert that contradicts certain things, etc. The battle of the experts, we talked about that many times. I don't know how often it is that the defense then gets the DNA and they do their own analysis. That is very highly unusual. It usually, once the DNA has been analyzed, then the experts get to analyze it, but you don't get to do your own tests on the DNA. So I find it interesting that they may or may not let this happen. What I'm potentially thinking is that if it's viable DNA, that's the number one, that's number one. Is it viable? And then if it's viable, then SLED or the FBI or whoever has it in their custody and control isn't just going to give it to Alec Murdaugh's people and be like, okay, you can do whatever you want. They're not going to do that, right? Custody control, right? SLED or FBI or whoever has it they will be the people then to send it to Ortham Labs. Just like in the Kohberger case, right? They sent it to Ortham Labs. It's not gonna go through another party to another party. Now, I thought that I don't even remember who that guy was. Who's the defense attorney that just spoke? It is. I wrote it down, but I don't know. My notes are quite all over the place. Okay. I'm not sure who the other defense attorney is. Remember, I'm new to this case. I didn't remember who's who. what's what, et cetera, et cetera, et cetera. So the defense attorney who's talking about the DNA, I forget his name. I wrote it down. Anyways, he stated all about the Koberger case, right? And that's what I said. I said, oh, Ortham Labs. I know Ortham Labs. They're the ones that figured out the DNA for Brian Koberger. And I've talked about this many, many times, right? It's called IgG, Investigative Genetic Genealogy. And basically what it is if you or your family members or somebody did a genetic test through Ancestry, through GEDmatch, through 23andMe. Now, some people are like, not 23andMe, but I'll get back to that, okay? What happened in the Koberger case was that they found that there was touch DNA on the button of the sheath that the knife was in. And they had that immediately because that's the first thing. Everybody, do you have DNA evidence? That's number one. So they found it. And then I forget the sequence of things, but it ended up going to Ortham Labs. And then they did their testing. Then they went through the family genetic tree and found somebody of somebody. It goes on the male family side. So they found a family member that was male, and then they linked it down to his dad. And then remember, they did the garbage pull. They found DNA from his dad, and then it ended up leading to him. And then when they arrested him, they took his DNA just to make the final confirmation. Yes, this is the person who left the DNA on the knife sheath. So, but that takes time. And they said it takes about 6 months. 6 months. So first you have to kind of go through the red tape with SLED and whoever has the DNA, then for them to give it up to Ortham Labs to do the testing. And they said 6 months. So when the judge said, oh, we're going to set a trial date for April. If you saw me, I was counting on my fingers. Let's just say in this next month, let's say in the month of July, they end up giving it to Ortham Labs, right? So that is, we're not going to count this month. Say it's going to take them a month just to get it to them. Okay, so August, September, October, November, December, January. January, they might have the DNA evidence of who that person might be, and then they can do some investigative work. The trial is slated for April. So January, February, March, April. That gives them approximately 2.5 months, just give or take, right? Is that enough time? Maybe, maybe not. So that was very, very interesting. And let me know if you in the comments if you have any questions about the DNA, Ortham Labs, and what have you. I can go. We could do a deep dive about that. We could do a deep dive. Okay, let's talk about 23andMe. Yes, 23andMe says that they aren't going to sell your information. But if you do not know, 23andMe has sold the company to somebody else. And they're everybody's in, all these big companies are in it to make money. Nobody's just a wallflower. Nobody's just going to sit by and be like, no, we're going to protect your data. How many times have you received notice that your internet data has been breached? Through your healthcare places, through your banking, through Apple Pay, through whatever, right? How many times have you seen your data has been breached? If you've given your DNA to 23andMe, I can guarantee you, mark my words today, it is the 29th of June. I betcha they're selling your stuff. Just saying, they got to make money, etc. So be cautious with your DNA because it's going to go. Now, some people are like, it's a big controversy. Some people are like, oh, well, it's okay. They're going to catch criminals. Well, I say, sure. But what about the future? Like, let's just say you gave your DNA and your grandkids, somebody committed a crime or somebody touched something and then they falsely accuse them. I'm making something up. They falsely accuse them and say, you committed a crime because we got your DNA and la, 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 la. Just saying for the future, that might be an issue. I always tell people, make sure that you protect your phones because your phones can be used against you. Your data on your GPS can be used against you, and so can your DNA. So be cautious with it. All right, moving on. Change of venue. Well, you let me know. Do you think that there should be a change of venue? I say yes. And if the prosecution doesn't agree, I say, sir, you just had a huge trial that was totally overturned. You might want to change the venue. I say yes. They're supposed to be working together to find out whether or not they will change a venue. I think the answer is yes, and I think that they should. Protective orders. I think, yes, some of the stuff should have a protective order on it. Nobody needs to see footage and stuff like that. No, they don't get a new judge. The judge in the last case was Judge Newman. The new judge is Deborah what's her name? I have it here somewhere. The new judge is Deborah something another. One moment. McCaslin. Deborah McCaslin is the judge. We just saw the hearing. That's the new judge. She will go wherever she needs to go. The judge stays the same. They just change courtrooms. And then they pick a jury from that county, wherever courtroom they choose. Right now they're in what did she say? Lexington. This was in they were in Colton County before. I don't know the counties in South Carolina. Let me see. What are the counties in South Carolina? Oh, there's so many counties in South Carolina. Oh, shoot. Hang on. I'm trying to see this picture and it's super tiny. So they were in Colton County before, and now she's in Lexington, which is that's where they're at currently because that's where she sits. That's where she's a residing judge on the bench, but she goes from county to county. Colton County, at one point in time, had a population of about, let's say, 40,000 people. That was in 2018. I know there's probably more. And Lexington is a much, much larger county. In 2018, they had almost 300,000 people. So, should they stay in Lexington? Probably. It's going to be a larger population. Are they going to get jurors who don't know about this case? I doubt it. It was very popular. So, will they get a jury? The answer is yeah, they'll get a jury. It's going to take some time, but they'll get a jury. So the next hearing date is August the 14th. Will it be televised? Oh, you bet it will be. Why? There is so much interest in this case. It's going to be televised. So mark your calendars, August 14th. We will definitely revisit that. And a potential trial date is set for the 5th of April. A protective order. We talked a little bit about that. Protective orders are what can the public see, what can't the public see. So during these pre-trials, up to the trial, the lawyers file motions, and it's, judge, we want this. And then the other person says, no, you can't have this for XYZ. We want this to come for evidence. No, you can't have this. So it's sort of like the lawyers fighting back and forth. The judge is the ultimate decider. For example, he wants a laptop. in his cell or a laptop to go over stuff. State says no. He wants to change his clothes. State says no. So it's those sort of, or it's arguments on paper that the judge gets to read both sides, and then she usually makes a order or she makes a decision. I really like this judge. She was a little bit strict on when the order should come through. Usually when you write a motion, you have so many days to respond to that motion, and if you don't, the judge gets mad. She was very polite. She's what I call her Southern politeness right now, but I have a feeling she's gonna turn it up. She's like, it's all right that you didn't go ahead and do this, and usually I need this by this day. So she was very polite right now, but I bet you when it comes closer to the trial date, she will not be as polite. She's gonna be like, you have XY, you have 24 hours to get this done. Because she's on a timeline and she wants to get this done. She wants this to get off of her docket, which I like that. So I think right now she's just being polite. And, this was the first initial meeting for everybody to come in and talk to this judge and to have her say some of the things that are going on. So there's going to be a lot of motions going back and forth. In these motions, typically, they kind of spill the dirt before the dirt goes to the trial. And that's where we hear a lot of the stuff that happens behind the scenes before we jump into a trial. That's what I like to do. I like to do the research. I like to go through things, etc. Sometimes we get all the things. Sometimes we don't get anything. So when we get to trial, sometimes we're not surprised. But sometimes we're like, is this going to come in? Is this not going to come in? What about this? What about that? And that's where we talk about things. Sometimes I like to jump into a trial where I don't know anything. And I'm just a jury sitting by looking and listening. That's what I did for the boat trial that I just did. But remember, I'm an at-home juror, so I get to Google things. But whatever. So I read the motions and I bring you the motions. And in fact, we're going to go over a motion here in just a minute. You're going to like this one. So in the motions, we get to hear things. Well, some things shouldn't because they're public record. So anybody and their mother can read these things. I bring them to you. Will that taint potential jurors? The answer is yes. Yes, it will. Yes, it will. If you know all the ins and outs of the case, they don't want you because you're tainted. You could be tainted one way or the other. So if I were to be a juror on this case, they'd be like, no, ma'am, Missy, you can't be on this jury, which is fine. So in this stuff, they're going to redact some stuff, meaning they're going to black it out or, put a big black thing in there or not show you some things. When it comes to like crime scene photos, we don't need to see that, people. Let's have a little bit respect for those who have been deceased. We don't need to see the crime scene photos. Becky Hill is not going to be out there selling the crime scene photos to other people, even though we already know that some of them are already out there. Once things are out there, you can't undo it because people can go out there and scrub things, but it resurfaces. That's okay. We don't need to see that. Some people know some things that have been, that they're going to redact. They already know some things. It's okay. It's okay. They're going to do their best to redact the things that, the average Joe doesn't need to see, which is fine. Redact away. So we will be reading motions and stuff and going through kind of what everybody says. Now, why is this so exciting? Well, I love a good argument. And these two lawyers are fabulous. If you have, just from this hearing alone, right? Your Honor, I didn't say that he needed to be shackled up. Your Honor, he's not a serial killer. I mean, come on. That's great banter, right? Just, if you saw my expressions, I was just like, oh, you did not just say that. And those are going to be great clips that I'm going to clip here and I'm going to put on reels and stuff like that are just fabulous. It's great fodder for television, right? So that's exactly the theatrics. Court is a theater, right? And who can put on the best theatrics? And both of these guys, Dick Harpootlian and Creighton Waters, are fabulous actors. I cannot wait to see this in motion. Now, Mind you, some people have already seen it, so let me know in the comments if you've already seen Trial 1 and you know what's going on and you know these characters. That's great. All right, Law Lovies, buckle up because guess what? I said I have a surprise for you if you didn't already know. If you didn't already know, let me see if I can find it. All right, here we go. If you didn't already know, Mr. Alec Murdaugh is suing Becky Hill. That's right. He's suing Becky Hill. That's right. If you didn't know, surprise. So let's read this. All right. The plaintiff, Richard Alec Murdaugh Sr. versus Rebecca Hill. The plaintiff, known as Alec Murdaugh, through his undersigned attorneys, brings the civil rights actions against defendant Becky Hill, former clerk of court for Colton County, South Carolina. All right, the nature of the action. On March 7th, 2023, following a 6-week trial in Colton County, South Carolina, Mr. Murdaugh was convicted of these murders of his wife, Maggie, and son, Paul. He was sentenced to 2 consecutive life terms. He maintained his innocence then. He maintains his innocence now. See, also the motions also have theatrics in them as well, and I'm here for it. Neither Mr. Murdaugh nor his counsel knew at the time of the trial that Miss Hill, the elected clerk of court of Colton County, the officer of the court charged as the primary caretaker of the jury, had secretly and deliberately inserted herself into the jury's deliberative process for personal financial gain. As the Supreme Court of South Carolina has now held, Miss Hill placed her fingers on the scales of justice. Acting under color of the statute of law and abusing the power and authority of her elected office, Miss Hill made repeated, improper, extrajudicial communications to jurors in which she urged them not to be fooled, confused, thrown off, or convinced by Murdaugh and his defense. In doing so, Miss Hill became a character witness on behalf of the state, encouraging the jurors to question Murdaugh's credibility and essentially implored the jurors to find him guilty, the ultimate issue in the case. Miss Hill's motive was her self-serving desire for her personal profit. She wanted to write a book about the most high-profile trial in South Carolina history so she could buy a lake house. And as the South Carolina Supreme Court found, she believed a guilty verdict would be the best way to sell books. She was, in her words, a former Chief Justice Toll, attracted to the siren call of celebrity, and allowed her desires for the public attention of the movement to overcome her duty to her oath of office. So, Judge Toll, why at that time did you think that she had this, that you didn't overturn the conviction? Anyways, it had to go to the Supreme Court. It's fine. It's fine, Judge Toll. We love you. Miss Hill's improper communications to the jury were deliberate acts repeated across multiple occasions, directed at jurors she was sworn to protect from the outside influence by an officer of the court, elected by the very people who make up the Colton County jury pool. Her conduct was, according to the South Carolina Supreme Court, breathtaking, disgraceful, and unprecedented in South Carolina. What great sound bites those are. On May 13th, the Supreme Court of South Carolina unanimously reversed plaintiff's murder convictions and remanded for a new trial, holding that Miss Hill's jury tampering violated Mr. Murdaugh's constitutional rights to a fair trial by an impartial jury. Mr. Murdaugh brings his action to hold Miss Hill accountable for her wrong conduct under color of state law and to recover compensatory and punitive damages as provided by law. Subject matter jurisdiction, factual allegations. Defendant Becky Hill began to enter the jury rooms often. As the defense began its case, Miss Hill told the jurors, "You're all going to be hearing things that will throw you off. Don't let this distract you or mislead you." Additionally, Miss Hill and juror number 826, the new jury foreperson, on multiple occasions went to another room to her private conversations lasting 5 or 10 minutes. Sometimes they would go into the jurors' room single occupancy bathroom together. Four-person juror number 826 never said anything about the content of those conversations to other jurors. Ms. Hill even instructed jurors that they could not ask four-person juror about the conversation. 2 days later, on Thursday the 23rd, continuing through the next day, Mr. Murdaugh testified in his own defense. Before he began his testimony, Ms. Hill told the jurors, "Do not be fooled" by the evidence Mr. Murdaugh's attorneys presented, which at least one juror understood to mean that Mr. Murdaugh would lie when he testified. Ms. Hill also instructed the jury to watch him closely, to look at his actions, look at his movements, at which at least one juror understood to mean that Mr. Murdaugh was guilty. Immediately after Mr. Murdaugh testified, four-person juror 826 told the jury that Mr. Murdaugh was crying on cue. She also criticized the former four-person juror 589 for handling Mr. Murdaugh a box of tissues when he was crying on the stand, because that is what the defense wants us to do. The next court day after Murdaugh's testimony on the 27th, Ms. Hill told the trial judge about a Facebook posting she purportedly saw on the evening of the 24th while pursuing a Facebook group called Waterboro Word of Mouth. We all know the egg juror, etc., etc., etc. The apology post. Juror 785's ex-husband, Egg Lady, has averred to in a sworn statement that he had made no such post. Mr. Murdaugh has obtained an authentic download of the entirety of Mr. Stone's Facebook activity, which confirms he did not post the apology. So, who did? Miss Hill questioned juror 785 about the fictitious post on Waterboro Word of Mouth. Alone in her office in the courthouse, she told juror 785 that someone had emailed her stating her ex-husband posted a Facebook page, and juror 785 had been drinking with her ex, and that while drunk, she expressed opinions of guilt or innocence of Mr. Murdaugh. Poor juror 785. I think she was the egg lady. There's a lot about that. If you want to go and look, we've had some previous discussions about that. All right. So what I'm trying to get to is, what does he want? What is he looking for? We've already read a whole bunch of this. We've gone through all of this. If you want, I'll post this on my Facebook page if you want to read it for yourself. All right. Jury tampering in violation of the 6th and 14th Amendments to the United States Constitution. Okay, so prayers for relief, judgment against defendant in this matter in a sum sufficient to adequately compensate him for damages suffered, for punitive damages, for reasonable attorney's fees, for the cost of this action, and for such other and future relief as the court may deem just and proper. All right, so there's no specific dollar amount, but you best believe it's going to be a lot. All right, Philip Barber, that was the attorney that was standing up talking about DNA. That's his name, and I should remember that name. Okay, Philip Barber, and then he is an attorney under the Harpoonian name. All right, and I believe Miss Becky responded. So let me put this on Facebook just so far because I have it. One moment, please. All right, I didn't want to clickety-clack in your ears, so I posted that on Facebook if you want to go and look at that. That's very interesting and very telling. And then somewhere I have here Here it is. One moment. I think I have Becky's response. What is she going to say? No, Your Honor, I didn't do any such thing. I would never. I'd never do that. All right, one moment. Let me bring it up on my end so we can read it. And I'll post this too. All right. All right. The plaintiff. Okay, it's to the Murdaughs. All right. You will please take notice that the defendant, by and through the undersigned counsel, respectfully moves this court to dismiss the plaintiff's complaint for failure to state a claim upon which relief can be granted. Da-da-da-da-da-da. Federal Rules of Civil Procedure dismissal. So, you cannot be outraged when somebody files a civil suit and then somebody asks for it to be dismissed. For example, in the boat crash, the George Pino case, if you followed me on that, when his lawyers were on the stand in the civil case, and the prosecution's like, well, you asked for a dismissal, so you didn't want this to go. You weren't trying to do everything in your power to make it whole. She's a lawyer. She knows it automatically goes up. The first thing you do is ask for a dismissal. That's the first thing that you do. So it's not a bad thing. And I don't know why she did that. It was just, I felt icky when she did that, but it is what it is. All right. Plaintiff alleges in short that the defendant's actions deprived him of an impartial jury and that he is therefore entitled to recover the full sum of the money. That doesn't make sense. I'm reading exactly what it says. Entitled to recover the full sum of the money he spent on his criminal trial defense. Such damages fall outside the scope. The Fourth Circuit has never established that damages stemming from legal costs associated with defending an underlying criminal case are redressable under this statute. Further, to the extent that the other circuits have considered the question, they, along with the Fourth Circuit, have been clear that in the event such damages are recoverable, a plaintiff must show that his damages were caused by the defendant's actions. Such cannot be the case where the entirety of the economic damages claimed by the plaintiff would have been spent on his criminal defense regardless of any actions taken by this defendant. Similarly, and for much of the same reasons, defendant is entitled to dismiss a plaintiff's claims pursuant to Rule 12b1 in the Federal Rules of Civil Procedures, where the compensatory damages sought by the plaintiff are not traceable to the defendant's actions. Finally, to the extent, if any, the plaintiff argues otherwise, that inconsistent with the complaint, he seeks damages related to the second future trial. Finally, and most critically, even if the plaintiff states a compensable claim, defendant is nonetheless entitled to 11th Amendment immunity, quasi-judicial immunity, and qualified immunity, all of which bars plaintiff's suit. Defendant's arguments and legal authority are contained in the memorandum of law submitted herein. So, I had thought about that. So, like for example, in Karen Reed's case, they cannot go back and sue Judge Cannoni for any misdeeds, right? Because judges have immunity. Does the clerk of court have immunity from prosecution? Oh, not prosecution, civil actions. Hang on, let me do a Google search. 1 second. Okay. It says court of clerks generally have absolute derived judicial immunity from civil suits for actions taken while performing tasks that are integral related to judicial processes. However, this immunity does not apply if the clerk steps outside their official duties or performs strictly administrative ministerial tasks. So interesting. There's a difference of opinion. Some say she has claimed immunity in a federal civil rights lawsuit against her, but the court hasn't ruled. We know that, and it said that she is not considered immune. So we will have to see whether or not Becky Hill will be immune from the civil suit. All right, law lovies, I've been on for over 2 hours. I hope you did the likey, the subscribey thing. So now I've got to go through and get those sound bites and make them into reels and TikToks, because that's what a lot of people are liking, is just the quick sound bites of the things that had happened during the hearing. So there are a whole bunch of law things going on. So tomorrow morning, join me as we are going to go back to Karen Reed La La Land. Why? Because there are so many things going on in that saga. That's the saga that will continue for on and on and on. Michael Proctor, did he show up for his deposition, and what happened? Aidan Carney is looking to get Michael Proctor's text messages because he hasn't received them in his own witness intimidation case. Is he able to get them? His attorneys filed a lovely motion about that. So we're going to go over that emotion. We're going to talk about the hearings that happened last week. We're going to talk about what future hearings are going on. Then there's a whole bunch going on in all of the other cases. Remember that there are 4 civil cases that Karen Reed has either pending against other people or against her. Stay tuned, because the Karen Reed saga never ends, and it won't end. But here we're talking about Murdaugh. So if you want to hear all the stuff about Alec Murdaugh, that's where we're headed. So make sure to like and subscribe, because it's going to be very intermittent at the time. Motions are going to be coming out, so I'll give sound bites and stuff about the motions. There's going to be another hearing on August the 14th. So make sure to put that on your calendar, because we'll be here to cover that. Then there's probably going to be more pretrial hearings. Probably they usually do it about a month, just like in the Karen Reed's hearings. They do one about every month, because the judge is trying to keep that case on the tracks, on the rails. Missy, does this happen in every civil case? The answer is no. No, it doesn't. Now, remember, Alec Murdaugh has a criminal trial. And criminal trials go a little bit faster than a civil trial, because somebody is being held, right? Currently, right now, yes, Alec Murdaugh is being held in jail from his financial crimes. And just FYI, he's not going anywhere. The financial crimes, he's in jail. He's not going anywhere. He's not going to be released. If by chance he's acquitted of this case, he's still in jail for those financial crimes. With those financial crimes, I don't know how much he's in jail for, but we can go over that later. So, Alec Murdaugh's not going anywhere. But he still has rights under a criminal trial, that he has to have his case going down the tracks and progressing to get him to a trial date. And just as the judge mentioned, she has a docket of trials and cases, and she's like, this is the oldest one that I have. So she does not like that, which is the reason why I like her, because she's like, let's get this moving. Let's get this moving. And most trial judges do that, except for, well, Boston. And if you know Boston, they're just like, hold my beer. You got a criminal trial? We'll just kick that can down the road. And when I say that, let's talk about Aidan Carney, right? Aidan Carney's witness intimidation case has been going on since what? 2022, 2023. Similarly, he's got two different cases, 2022 and 2023. It's 2026, people, and he's still snoozing away. They keep pausing, we'll just keep putting snooze on that. So some judges want things going, some judges don't. All right, law lovies, we are about to end this stream. If you have any questions or comments, the chat is open if you want to talk. If not, we are going to stop the stream. I'm going to make some tickety talks and some reels to put up for everybody, and then we'll go on. And then tomorrow we are going to talk all Karen Read, unless something else pops off, which usually does. So, oh, I also wanted to mention cameras in the courtrooms. I failed to mention this earlier. And I said, oh, Missy, is the August 14th one going to be televised? I said, oh, you bet it is, because this is a very high profile case and all eyes are on this round 2. So as you saw, Court TV had already made a motion to the judge. I want to be in the courtroom. She's like, here you go. There is a proposed bill that has been passed, and that they are potentially allowing cameras to be in federal courts. Missy, federal courts. What does that mean? Well, so you know that some criminal cases are held locally in your own counties, and then some are federal. Why? We can get into that. That's a matter of legal law, legalese. Federal courtrooms do not allow cameras in the courtroom. But through transparency, right, to make more trials public to the public, they're thinking about opening that up. Missy, what does that mean? Well, think about all the federal cases that are just sort of in our repertoire at the moment. We have Sean Diddy Combs, right? He is a federal case, even though he's already been convicted and he's serving, 3 years, 5 years. I thought I heard his sentence got reduced again, so he's going to be out next year sometime, I think. Are the feds going to try again? Oh, probably. Usually once you're on the federal radar and they somewhat lost, they don't like to lose, so they're probably going to try to get him on something else. That's for another day. Sandra Birchmore's case, that's a federal case. One of Karen Read's civil cases has been moved to federal as well. And so will cameras be in the courtroom for that? Who knows? There's a lot of interest in it. So I know a lot of people are going to be like, yes, let's have cameras there. So we shall see. Sometimes they have Zoom hearings. Zoom hearings are typically you're not allowed to live Zoom a Zoom hearing for attorneys unless you have media privileges. So now a lot of people are getting media privileges to disseminate that information live. So it's ever evolving. As they were talking earlier about DNA. DNA is ever evolving. Technology is ever evolving. So is the public's interest in trials. And it is integral to our learning process that we get access to these trials so that no shenanigans can take place. For example, Misty, it's 2026. How can shenanigans take place? Oh, hold my beer. I've got a case for you. If you haven't heard me talk about the Aaron Spencer case in Lonoke, Arkansas. 2 judges there. Judge Barbara Elmore. Apparently, she's not a good judge. And she tried to limit the people in the courtroom, which is against the rights of the accused. There were a couple of other things that she did. She wouldn't allow some expert testimony. She was sort of handcuffing the defense. And if you do that, you are violating the civil rights of that criminal. And it was so egregious that his defense attorneys wrote a motion to remove her as a judge, and it went up to the Arkansas Supreme Court, and guess what? They agreed, and they removed her. So why Now, some people also state that the judge in the Delphi murders was egregious as well, and limiting things in the courtroom, et cetera, et cetera, et cetera. And so some people felt that she too should have been removed, and she allowed some things and didn't allow some things, et cetera. So he has an appeal, and we'll see whether or not his appeal will be overturned or not. So many things. We still are awaiting the Charlie Adelson appeal, just FYI. Let's just double check on that and see if we have anything. All right, so far there has been no word on Charlie Adelson's appeal. Just FYI, Charlie Adelson, if you don't know, that was a Florida case. He was convicted of conspiring with his mother. Well, she eventually got charged and she's in jail. He conspired with his girlfriend, who conspired with her baby daddy, who conspired with his friend to kill his sister's ex-husband because they were fighting over custody and control of the children. Wendy Adelson wanted to have the kids stay in wanted to move the kids to Miami because that's where her family was from. He lived in Tallahassee. And so if he was gone, then she could have the kids free reign, right? And so that's what happened. So his case went up on appeal. His lawyer, Mr. Ufferman, did a great job, but I thought that they made some weak arguments. So anyways, we have a couple of appeals that we're still waiting for as well. All right, Law Lovies, thank you for joining me on this lovely Monday morning. It is a heat wave here for us. I don't know if it's a heat wave for you, but hopefully you are able to stay cool. And if you have any animals outside, make sure to go check on them and make sure to give them water and food and make sure they have some nice shady shelter, because that's what I have to go do. We had a cat family adopt us, and so now we have a whole bunch of cats, and we are looking for homes for them, and we're working our way through it. So I got to go check on the cat clan outside. So thank you so much for joining me. I appreciate you. Do the likies, the subscribies, the sharey things, whatever, so the content gets out. And we will see you again tomorrow morning to go over Karen Read or whatever the heck pops off for Law Talk Tuesday. So thanks for joining me. We'll see you again tomorrow. Bye-bye. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.